Former Supreme Court Justice Jonathan Sumption writes this week's cover piece about the case for leaving the European Convention on Human Rights. The convention, he says, has become intrusive and banal. To expound on his argument, Jonathan joins me now alongside the former Attorney General Dominic Grieve. This week, Jonathan, you write the cover piece, which is about the case for the UK potentially leaving the European Convention on Human Rights.
Yes.
Can you explain your argument for us?
I've got no problem at all about the text of the convention. I do have quite a serious problem about the way in which the text has been treated by the European Court of Human Rights in Strasbourg. Since the 1970s, they have operated in accordance with what they call a living instrument doctrine. And that essentially has been treated as a way of expanding on the text by a process of extrapolation and analogy, so as to produce a very large number of rights, some of which are loosely ancillary to existing rights, but many of which are freestanding. I think that this is an essentially legislative process and involves a usurpation of the function of democratic legislatures. We do not need the Human Rights Convention in order to protect human rights, but I certainly wouldn't like to see it abolished unless we replace it with something equivalent. So what I would suggest is that we should replace it with something that would look very much the same as the Convention, but which would not be subject to the jurisdiction of the Strasbourg Court.
Dominic, what do you make of Jonathan's argument there?
Start with something we agree on. I'm certainly in agreement with him that if the United Kingdom were to withdraw from the European Convention on Human Rights, but continue, for example, to operate the Human Rights Act as its domestic Bill of Rights, then I think our human rights in this country would continue to be pretty well protected. There is a risk that in certain circumstances, on a declaration of incompatibility, Parliament and government might decide to do nothing about it, but Jonathan has a perfectly good point that can be argued to be within the way a democracy operates if it's fully debated in Parliament. But that, for me, is not why we signed up to the European Convention on Human Rights in the first place. We signed up to it because it was an international treaty that was intended to confer international benefits on the United Kingdom, raising the standards of human rights in other European countries, which in my view it has done exceptionally well, and at the same time showing that we were prepared to be bound by this international convention, which is ultimately interpreted by an international tribunal, the Court of Human Rights, as a way of persuading those other countries to adhere to it. And the difficulty is that if you decide to leave it, you are going to have a whole series of consequences that will flow from it. And it can be listed quite easily, some of them. One of the early ones is that our trade and cooperation agreement with the EU will undoubtedly be jeopardised. It may be possible to work around it. Our participation in the Horizon project would become impossible because it requires data sharing, and data sharing is seen as being absolutely underpinned post our leaving the EU by shared adherence to the convention. And in the context of Northern Ireland, there would be some significant issues about where Northern Ireland remained within the ambit of the convention or not, and how you would do that if a sovereign state withdraws, because it is explicit and implicit in the Good Friday Belfast Agreement that we would be there. So there would be very significant consequences. And like everything else in an international treaty, you should, if you're considering withdrawing it or participating in it, you should be weighing the pros and the cons. And where I think I disagree with Jonathan is that when it comes to looking at the downsides of this, then whilst I accept that the court has occasionally made decisions which I disagree with, and I actually think have been rather foolish at times, but then even our own Supreme Court has occasionally done decisions which I thought were rather foolish domestically. But when you actually look at the way this court is now operating, particularly since Ken Clarke and I negotiated the Brighton Declaration in 2012 and changed the way it operated, in practice we've had very little difficulty adhering to it. And actually the number of cases which have caused a ripple since, have been almost non-existent. I think last year, the best I would try to look it up before I came here, but as far as I could see, there were only 2 judgments against the UK that could be regarded as covering new ground, as opposed to cases where we hadn't dealt with a previous judgment and so another judgment came along. And they were both matters where actually the government was perfectly happy. One was bereavement support grants and discrimination, and the other one was about journalists being harassed by the police for tweets that the journalist considered was acceptable and the police didn't, and a wrongful arrest which followed. Most of the big issues, prisoner voting, whole life tariffs, have all been resolved without anybody really being aware it's happened. So whilst I accept that this court isn't perfect, no human institution is perfect. Sure. I think that the reputational consequences to the United Kingdom of leaving and the practical consequences of leaving vastly outweigh any possible advantage that it might confer on us.
What do you think about that, Jon?
Well, I fundamentally disagree with much of that. Most international multilateral treaties are designed to enable one to achieve things internationally which we could not achieve on our own. This is a rather special case because the Human Rights Convention is a treaty which deals with matters, every single one of which we could deal with on our own. Now, what Dominic says is, well, it encourages human rights in other places. And that was certainly the rather patronizing basis on which we acceded to it originally. We basically said to ourselves that we already have all of these benefits. They've been part of English law for a long time, which was mainly but not entirely true. We're joining this because we want to confer the advantages that we've had for a long time on these benighted Europeans. That was essentially the attitude. I am sceptical about how much we have actually achieved internationally. There are countries which have been released from decades of tyranny in Eastern Europe, who have been desperate to improve their human rights record and have successfully done it. I believe that they would have done it whether the United Kingdom was party to this treaty or not. There are other countries like Belarus and Russia, and to some extent Turkey, which have set their face against giving effective scope to the Human Rights Convention, in spite of the fact that they were parties to it, and no amount of adverse judgment has improved their degree of compliance. Russia was expelled from the Council of Europe last year. Belarus has not been expelled, but its human rights record is absolutely dismal. The participation of the United Kingdom in the convention has made absolutely no difference to them. There are some things which I would accept. First of all, I would accept that if we withdrew from the convention, we would not be able to withdraw from it in respect of Northern Ireland, yes, because the Good Friday Agreement specifically requires that we confer on them not just human rights, but the human rights envisaged in the convention. So I think that unless something could be negotiated with the Irish government, which I regard as most unlikely, we would have to leave Northern Ireland in the convention system. I don't accept that it would create problems with the EU. The EU treaty requires its members to have satisfactory arrangements for preserving human rights. It doesn't require its members to adhere to the convention, although they all do. It seems to me, therefore, that if we had a system of human rights which was dependent on enforcement by independent judges who are perfectly up to the job, which would be the case in this country, I think the EU would probably accept that. The problem really is that we have to decide not whether we like this or that or the other decision that the Strasbourg court makes. People will no doubt differ on that. The real question is, how do you make law for a democracy? And the problem that the Strasbourg court raises is that whereas if you have a wholly domestic system of human rights protection, if something goes wrong if courts make silly decisions, which they sometimes do, I quite agree with Dominic about that, you can deal with it, you can correct it, because you are basically masters of the national scheme yourself. But there is absolutely no way of correcting the errors of the Strasbourg Court. The members of the Council of Europe have no input whatever into its decision-making process. Now, Dominic cites the Brighton Declaration. I have to say that the Brighton Declaration has, in my view, made very little difference to the way that they operate. I spoke only the other day to two members of the court who said, that we look intensely with great care at the subsidiarity and all these other things, many of which are basically reflected in the Brighton Convention. But the test is whether this can be seen in their decisions, and I don't believe that it can.
Well, I obviously disagree with that, and just to give a couple of examples. Firstly, there is a degree of dialogue between our own national courts and the Strasbourg Court, which can continue even when the Strasbourg Court's made a decision that we think may be wrong. When examples of this are around, and the Strasbourg Court does listen to what our own Supreme Court does. So, for example, political advertising, which I think was seen as being a restriction on freedom of expression when it was first being considered in Strasbourg, once the Supreme Court had explained why we had such rules on managing political advertising. It stopped. Same with rules on hearsay in criminal courts. You could argue that actually there was a very extensive dialogue over prisoner voting, so eventually it was resolved by a minute change to the prison regulations. And I accept this is not a perfect system, but it is one where there's undoubtedly dialogue, and the dialogue is all the better when there's trust. One of the problems is when the United Kingdom starts huffing and puffing and saying it's about to pull out, when, if you want my personal opinion, there is no prospect whatsoever of it happening under the present government at all. So this is another sort of pre-party conference puff, I have to say to you. Every time that happens, it reduces the trust, and the reduction in the trust then leads to examples like applying Rule 39 and giving an interim order to prevent deportation to Rwanda, which I happen to think was completely unnecessary, because I at least do have confidence that if the United Kingdom were ultimately to have a judgment against it after it had deported somebody to Rwanda, we'd have brought them back. But equally, turning that into some great issue, in my view, when it's just a procedural matter, is to exaggerate the problems and failing to see the advantages. And I do also fundamentally disagree about the issue about impact. And just to take two examples, adherence to the convention is seen as a benchmark and standard of human rights. It even has a positive impact outside of convention countries. Theresa May's willingness to take the brickbats from the tabloid press of Abu Qatada ultimately led the Jordanian government changing its own criminal justice system to prevent the admissibility of evidence that might have been obtained under torture, which is something I think we would all think was a good thing. And at the moment in Azerbaijan, in Nagorno-Karabakh, you have a humanitarian crisis brought on by the fact that the inhabitants who are legally in Azerbaijan, whatever has been happening there previously, are in great fear of persecution in their lives. The Azeri government, for all its faults, is a signatory member of the convention and will be placed under very considerable pressure as to how it operates in respect of a minority community. All those things, in my view, are advantageous. And I happen to think that Jonathan is underestimating this bit of UK soft power. At best, we've been seen as leaders in this, and it has, particularly in the ex-communist countries after the wall came down, which often had no traditions of democratic accountability at all, and a lot of authoritarian administrative decision-making, it's made a very great impact. And finally, I disagree, because Jonathan characterised international treaties as being there to regulate relations between states.
No, I didn't do that.
Well, that's roughly it. But since the Second World War, a lot of international treaties are about the behaviour of states towards their own citizens and a willingness of states to circumscribe their sovereignty in order to achieve certain standards. And obviously a question arises, on the question of democracy, is that acceptable or not? But I think in the overall context of democratic government and trying to achieve both democracy and freedom and the rule of law, I think it's a balance that we've probably got just about right. I'm not saying that there aren't frictions, and I'm not saying that the court in Strasbourg always gets it right. But I think that to simply say you should just leave this entirely to sovereign governments to get on with, I think we will then find that overall the standard of human rights that we enjoy, particularly on the European continent, will slip.
Well, I think that all the advantages which you cite are perfectly capable of being achieved if we have a reputation for defending human rights domestically. I don't think that we need the convention in order to do it. I entirely agree that there is dialogue between our courts and the courts and the Strasbourg court. And I also agree that there are some cases in which the Strasbourg court has, usually without admitting it, been prepared to back down. But for every case like that, there are a number of cases in which they have not backed down. I mean, just to cite two examples, the Strasbourg court has made policing in countries of the Council of Europe, including ourselves, very much more difficult by considerably restricting the amount of intelligence that they can retain or the kind of evidence that they can use. Another example, the Strasbourg court has made it extremely difficult for European armies to participate effectively in peacekeeping operations by purporting to extend the convention to the activities of armed forces in places like Afghanistan and Iraq. In the process, it has made it extremely difficult to retain prisoners of war, to the immense dismay not only of countries with peacekeeping forces in these places, but also of the Red Cross. I think that Dominic is absolutely right to say that the picture is not an even one. There are examples where the system works satisfactorily, but there are too many examples of cases where it doesn't work at all satisfactorily for this to be a sensible way of making law for our society.
I think you both agree on the fact that I think the debate around the ECHR has often been quite a facile one. And
yes, and I wouldn't pin it on immigration, which has, I think, got very little to do with human rights convention. The problems that we're having are due to other factors. And I wouldn't therefore want to withdraw simply because of, e.g., the admittedly disgraceful behaviour of the Strasbourg court over Rule 39 and Rwanda. I mean, I've got very little patient time for the Rwanda scheme. I don't think it's going to work. But I think that the way that the British courts were treated over that was, and indeed the British government was treated, was frankly disgraceful. But I don't think one should take single incidents and treat them as a reason for withdrawing. That is just rhetoric. I would say my views are essentially based on the experience of decades of Strasbourg jurisprudence. And I originally felt we should perhaps wait to see whether they could reform themselves internally, whether the Brighton Declaration would work. I have very reluctantly come to the conclusion that this is too ungainly an institution with too much esprit de corps and too much ideological commitment to change.
And how do you see this debate unfolding in the coming years? I mean, the Conservatives have been talking about it ahead of the conference season, as Dominic mentions, but where do you see it?
Well, my position is a minority position, both in the country at large and I think in Parliament and indeed even within the Conservative Party. I recognise that. But the fact that I'm in a minority isn't going to stop me from pointing out the costs that we have to pay.
Dominic, do you think it's going to be a stable part of British life, more debates around the ECHR?
Well, the debate around the ECHR has been running a long time. Admittedly, it's principally been focused on getting rid of the Human Rights Act, having a Bill of Rights, and somehow staying compliant with the ECHR, even though there's a desire to make it non-compliant. And that has been a 15-year, utterly sterile argument. It led to the sacking of at least one Attorney General I can think of. And at the end of it, we have made absolutely no progress because it was a very poorly thought out scheme. Now, I accept actually that logically leaving the ECHR entirely has a more logical ring to it, but it also brings with it these consequences. And it's obviously an area where Jonathan and I, whilst we agree on some things, also I think have a sort of fundamentally different take on the advantages of internationalism. I was Attorney General when the Court of Human Rights started creating difficulties over detaining battlefield combatants in Afghanistan, and I entirely agree with him. I think they had got the wrong end of the stick very badly. But actually, some subsequent jurisprudence suggests that we've got out of that, and they've now understood that, in fact, international humanitarian law has got to be taken into account, the law of the battlefield. So, whilst I accept that there are hiccups, irritations, things I disagree with, and like any international court with 46 judges on it, there are going to be issues around that. Actually, I don't think it is doing us anything like as much harm as Jonathan thinks, and I think it is a vehicle for continuing to do good. And for that reason, I think that this argument will not go anywhere, because I don't think a UK Prime Minister, whether it's Rishi Sunak or turns out to be Keir Starmer after the next election, is going to be minded to start tinkering with our adherence to a treaty which, and here I disagree with Jonathan, is seen as really fundamentally important by our EU partners in terms of our continuing relationship now we're out of the EU. So the political consequences of that being so profound, and with it, the economic consequences that might go with it, I don't think it'll happen.
We look forward to covering that debate in The Spectator. Thank you, Jonathan. Thank you, Dominic.